Okay, Your Honor, we're ready.
All right, thank you. This is case CR 22-21-1623, State versus Chad Guy Daybell. This is the time we have set for a hearing on the state's motion that was filed on the 20th. It's a motion to correct case heading and clarify the court's order dated August 6, 2021. Appearing for the state on this matter is Lindsay Blake. I believe you're going to be arguing the motion. Is that correct, Ms. Blake?
That is correct, Your Honor.
All right, Mr. Wood and Ms. Smith are also appearing for the state. Appearing on behalf of the defense is Mr. Pryor. Mr. Pryor, your client is not present. Does he intend to appear at this hearing today?
He does not, Judge. Thank you.
All right, did you advise him of his right to be present for this hearing this afternoon?
I did, Your Honor.
And is it your representation then that he agreed to waive his right to be present for this hearing?
Yes, Judge.
Very well. We'll excuse his presence then. Mr. Archibald is here representing the co-defendant in the companion state case, which is case 21-1624. Mr. Archibald, do you know if Mr. Means was intending to appear today?
Your Honor, I talked to him this morning. He was on the road. He didn't know if he'd be able to appear or not. I understand this hearing is not in the Lori Ballo case today since the case has stayed, but just in Mr. Daybell's case only.
Okay, very well. I think we've got all counsel present and accounted for then. So at this time, the court has reviewed the motion. I'll note it was filed just 2 days ago, but that was on a scheduling order the court discussed with counsel. So there would not be an objection to hearing this on shortened notice since the issue had been raised previously. So with that in mind, I would indicate there's not any filed response. Are you going to present argument in response, Mr. Pryor, or did you file anything in response?
I don't anticipate a response, Judge. Simply what I anticipate saying basically is the manner in which this court is conducting this process, we find appropriate, and I'll leave it at that.
Okay, thanks, Mr. Pryor. So Ms. Blake, if you'd like to present argument on the motion at this time, please do.
Thank you, Your Honor. I would indicate, just so the record is clear, the same motion was also filed in Ms. Ballo's case number as well. Given the nature of her case being stayed, the state understands that we will not hear it in that case today, but the same motion is currently pending in case numbers ending in 1624.
Okay.
So as the court noted, the court and counsel has received a copy of the state's motion, which was just filed a couple days ago. We recognize that as a pretty quick filing. However, this is an issue that the state has continued to bring up and have concerns with. It's the state's position that this case was, while we have two case numbers, that this was actually returned as a single joint indictment. It was the state's intent and the state's prerogative to choose to file it as one case, present it to the grand jury as one case, and request a single indictment be returned, listing both co-defendants in one case number. Ultimately, this ended up being split into two case numbers at the outset of the case. As time went on, the court did issue an order on August 6th, kind of explaining that. However, it has still left the state with a couple concerns. So the state looked at Idaho Criminal Rule 8, which deals with the joinder of offenses and joinder of defendants. So specifically, we're looking at the joinder of defendants. We do have multiple offenses charged in the same indictment as well, though. But with regard to the joinder of defendants, the state's interpretation of that rule is that if it's a common scheme and plan, the state has the option to file as one. I think there's multiple cases that discuss severance, and they talk about severance under two different theories. The first theory would be, or the first argument would be under Rule 8, under Idaho Criminal Rule 8, if a party wanted to argue, and generally that would be the defendant, wanted to argue that there was not a common scheme or plan or a series of transactions, and that the case was initially improperly joined. A court could determine that that was the case and separate them. It appears that a court may also have the option to determine that they feel that it was improperly joined under Criminal Rule 8. The other way in which a case can be severed in Idaho is under Idaho Criminal Rule 14. And I know that we're not arguing the severance today, but I think there's some crossover between these two issues. And so the state had discussed that as well. What's unclear under Idaho Criminal Rule 14 is if a court can sua sponte sever a case or if it needs to be a motion brought by one of the parties. Case law in Idaho continually specifically refers to the burden being on the party bringing the motion, and most often that is the defendant. So it's unclear from case law the interpretation of that Criminal Rule 14. However, what does appear to be clear is if a severance is requested under Rule 14, or if a case is severed under Rule 14, that there has to be a finding of prejudice, or there has to be some prejudice to either a defendant or the state. Most of the case law in Idaho really deals with whether or not the joinder of offenses was prejudicial, more so than really getting into the joinder of defendants, whether or not that's prejudicial. So in this case, where it sits right now is we have 2 case numbers and 2 tracks, but they are supposed to end up in trial together. So there has not been an official severance granted, but it appears to be a partial severance because we have 2 different tracks of the case. So generally speaking, and case law references this quite frequently, the idea of joinder of cases, there's multiple reasons to do it, but one of the biggest ones is judicial economy. Also, not adding additional burden to the state to present multiple witnesses, to have witnesses come in multiple times, present the same argument multiple times, and move forward in that way. So in this case, where we're at is exactly that position of having to argue the same motions multiple times, bring in the same witnesses multiple times. And to try to track this case together, the state has just seen that there could be some issues that may arise. So just looking at some of the pending motions we have, such as the motion to change venue, I think we're put in a position where moving forward on an issue like that, Ms. Vallow's case has stayed, or Ms. Vallow's side of the case has stayed, so she wouldn't be there to make argument, or her counsel, and a decision regarding Mr. Daybell's trial may be made.
Let me ask on that then, and this would relate to any other coming motion. Is it the state's position then I should grant this, have a single case, and everything is state?
That would be our position at this point in time, Your Honor. And so we did try to find case law here in Idaho, and it seems to be a novel issue regarding co-defendants in the stay of a case. However, the federal courts have dealt with this issue quite frequently, and the state does recognize that the federal system is a little bit different. They have some rules that are a little more black and white, and they have something called the Speedy Trial Act that they turn to. However, when we look at the Speedy Trial Act, it's similar to speedy trial in the sense that it is a calculation regarding when a defendant is taken to trial. And the federal courts have consistently found that if one defendant is causing a stay in a case, or I think the case law says if a delay is attributable to any one defendant, it's charged against a single clock, thus making the delay applicable to all defendants. If a defendant actually brings a motion to sever and it's denied, the court changes that analysis in the federal system, and they look at a reasonable delay analysis is applied to decide whether or not the delay should reasonably be attributable to another defendant and how to add that into their calculations. So again, the state recognizes their calculations are different. However, in several different federal cases cited by the state, the courts routinely found that joint trials serve the interests of justice by avoiding the scandal and inequity of inconsistent verdicts. And they found that while they had heard argument from co-defendants saying, because one co-defendant had delayed the case, that was prejudicial to the other co-defendant or a violation of the Speedy Trial Act, the courts consistently have found that it wasn't. Even if there was a motion to sever that was denied and they were applying the reasonable analysis standard, they still found that it was not overly prejudicial, and they found that keeping the trials together was appropriate. There wasn't a violation of the speedy trial, and there wasn't a violation of the court's discretion in denying the severance.
All right, Ms. Blake, though, on that point, would you agree there's got to be limits on the delay? The delays I reviewed in the cases you've cited, 4 months. One of them talked about 7 months. We've already got a 3-month delay based on a stay in the Vallow case. We've just ordered an additional 180 days where that stayed. And there's not only a statutory right, there's a constitutional right to a speedy trial. Even if it's waived, it's not waived forever. And I guess my question I'm posing to you is, again, so your position is that as of right now, Mr. Daybell's case needs to be stayed for 180 days because Vala's case is, and in that interim, he's not allowed to bring any motions, have any hearings, or move the case forward towards trial because of her competency issue. Is that where you're headed with this request?
Yes, Your Honor, I think that would be accurate. And again, looking at the speedy trial issue, because I think that's part of what those federal cases were focused on. In State v. Lopez, 144 Idaho 349, it cites to State v. Youngblood and indicates an unequivocal written waiver of speedy trial signed by defendant is dispositive of a later motion to dismiss on that basis. So the state does recognize, and even with a waiver of speedy trial, the state has never argued or would never argue that Mr. Daybell's case should be held in perpetuity. We believe absolutely at some point the state may join in a motion to sever or may believe that's appropriate. However, at this point in time, the state's concern is that the state opted to file this as one case. It appears to have been partially severed, and the concern is in continuing to move forward on motions only on Mr. Daybell's side of the case, we're concerned that it appears that it will eventually result in a severance or result in problems if Ms. Vallow is not allowed to be heard at a change of venue. And if Ms. Vallow isn't allowed to be heard at a motion to sever, because she may have, maybe she joined in the motion, maybe she wouldn't, it's unknown at this point in time. But it appears that if we go forward with these motions, then we run into the problem of, do we violate some of her rights in not allowing her to be heard? And one of the other pending motions is with regard to the consumption of DNA. And part of the problem there, and I think Mr. Wood briefly addressed this at the last hearing, is the concern is if the motion is granted and allows the court to consume the DNA, then would we be barred from using it against Ms. Vallow because she won't be allowed to be heard? And so I think it results in some concerns that way as well. So the state wouldn't argue that this should be held forever in perpetuity or stayed forever, but we do believe that it is appropriately filed as one case, and unless it's severed under either the analysis required by Idaho Criminal Rule 8 or Idaho Criminal Rule 14, and there's a finding of prejudice or a finding that it was improperly joined at the outset of the case, that it would remain joined, at least in the interim. Again, the state recognizes this position may change, and at some point this may need to be addressed, but we believe we're early enough on in the case and that case law clearly supports joinder of trials, even if there are co-defendants and even if there is a delay by one co-defendant, that it doesn't automatically require any kind of a severance. And we're just concerned about that. In addition, the other concern of the state is with the current order and to only file documents in each respective side of the case, the concern is if this does go to a joint trial, which is the current order, the defense right now is deprived of seeing some of the filings. The state at this point has been providing courtesy copies, but I think currently the defendants may not be getting copies from the other defendants' filings because we're filing in two separate cases. And in moving towards a joint trial, it would appear that that may be problematic if defense is not aware of all the filings that have occurred in a case that's going to trial together. So that was the other concern that the state had. But I think that covers essentially, as I indicated, I know we'd provided the motion that has some other case law and things. And if the court has additional questions, I'm happy to answer them. But that would be the state's position at this time, is that it should be joined back into one case number, one case heading indicating both co-defendants, that the cases should run together, meaning all filings should be done in one case number, all hearings should be held in one case, and we should proceed forward. Again, the state's position could change depending on the timeliness. We do recognize that at some point it may be more appropriate to sever them or to move Mr. Daybell's case forward, but we think we're still early on in the proceedings to have that requirement right now. And especially with the waiver of speedy trial at this point, I don't think that we're running afoul of Mr. Daybell's due process or constitutional rights at this point in time. The state worries the opposite will happen if we continue down two tracks, and that we may run afoul of the defendant's due process rights and constitutional rights as well. So that's the state's position unless the court has any additional questions.
Okay, I appreciate your argument on that. Mr. Pryor initially indicated you didn't have any response other than what you said at the outset after hearing the argument there. Do you have any responsive argument?
Unfortunately, Judge, I have something briefly to touch on.
Very well. Go ahead.
I thank you, Judge. I appreciate you giving me the opportunity. Judge, it seems to me that they're more concerned about case numbers on cases than they are about the law that applies in this case. This case hasn't been severed. This judge, you in particular, have not severed this case. There has not been a ruling severing the case. What this court has done is simply said this: I'm not going to infringe on Mr. Daybell's constitutional rights to effectively defend the charges against him. Because if we do what the state's suggesting, and the court obviously was astute enough to catch on this, that if we do what the state is suggesting, then there's a stay on Mr. Daybell. That means I'm not allowed to do anything until the state decides that they're going to agree to let this be severed. Well, unfortunately, it's not their decision. If they want it severed, they can file a motion. I have filed a motion to sever. I filed a motion for change of venue, and I believe I filed all the appropriate motions at this point. But what the court has done is said, listen, for the purposes of I-Court and the way things are identified on the I-Court system that we're now using, it's not inappropriate for Mr. Daybell to have a case number and for Ms. Daybell to have a case number. It's also not unusual, Judge, in the number of years I've been practicing, for when cases are joined, there's 2 case numbers on there with 2 different defendants. Sometimes there's multiple charges on each of the defendants and they're joined as well. So what's happening here is not particularly unusual. What it is happening is that the court is allowing Mr. Daybell to effectively do what he thinks is necessary to defend him in this matter and not have to wait for the state to decide, well, maybe we'll sever. Well, unfortunately, Judge, it's not their decision. It's this court's decision. And this court is given the inherent right to dictate the process, the procedure, and the manner in which cases proceed. Now, when the court put a stay on Ms. Vallow's case, the court was astute enough to say, I'm not going to infringe on Mr. Daybell's rights, and I'm going to allow him to do whatever is necessary and continue to move this along. Because if we wait for the state to decide when we're going to sever, is that going to be a year from now? Is Mr. Daybell going to be in jail for 2 years until we decide that, well, maybe we'll go forward? And then at that point, Judge, when we decide to go forward, if Ms. Vallow becomes competent in the future, at that point, are we going to be allowed to start all over again for another year and file all the necessary motions? Obviously, the court has enough experience to recognize that the way you're handling is absolutely appropriate. And the state has not provided a modicum of evidence or statute that supports what they're suggesting should happen. And quite frankly, there isn't a single statute, law, or case that I can identify, Judge, that prohibits you from doing exactly what you're doing. And I encourage the court to keep the same path and go forward.
All right. Thanks for the argument, Mr. Pryor. With that, Ms. Blake, if you'd like to make any rebuttal, since I allowed that response, you're allowed a rebuttal if you'd like.
Your Honor, I think I'd just respond briefly and indicate the state in no way believes that it's up to the state whether or not a severance occurs. As we indicated, pursuant to Idaho Criminal Rule 14 and or Idaho Criminal Rule 8, that decision would be in the discretion of the court. Case law indicates with regard to Criminal Rule 14 that the burden is on the party bringing the motion. What the state simply indicated is at some point the state may be in a position of believing that a severance is appropriate and requesting that or joining in a request from defense for that. We absolutely recognize that that is within the court's discretion. So I don't want there to be any confusion there. And then just lastly, I know the court and defense already have a copy of the state's motion, so I would indicate that within the state's motion, I think that's where we have appropriately identified the applicable statutes as well as case law regarding prosecutors having discretion with regard to charging decisions and how that has generally been interpreted by the courts, as well as the state's concern with the current severance or what appears to be a partial severance without any finding that it was improperly joined or a specific finding of any prejudice to one of the parties involved. So I think that's where the state's authority is mostly contained. I just didn't want to argue all of that today where all of the parties are in possession of that motion at this time.
Okay. Well, I appreciate the arguments on the issue. Council had considered that. I went back and reviewed the order that was entered in the case on August 6th. And the order is pretty clear on the last sentence of the first page that the defendants are joined for purposes of trial pursuant to Rule 8B. So the current status quo of the case is that the two defendants in this case, Mr. Daybell, Mrs. Ballo, are both joined for trial under 8B. I appreciate the briefing and the argument and pretty extensive citations to authority in the state's motion. I've reviewed that, and I guess a couple of things I take away from reading through that case law is, first, almost all, if not all, of the citations really deal with the issue of trial. So we're in a case, we're in the pretrial motions phase of a case. Eventually we get to trial, and most of those citations talk about trials. Joint trials serve the interest of justice by avoiding the scandal and inequity of inconsistent verdicts. That's one of the citations. There's another one talking about joint trials. There's a multitude of citations to joint trials. One of the cases cited that talks about delay was a delay because there were multiple defendants joined for trial, and some of the defendants were pursuing pretrial motions, which were taking a lot of time to get through the system. Other defendants were ready to go to trial, and the analysis is the pretrial litigation of certain defendants creating delays for the other defendants, violating the rights of the defendants that want to go forward. And the point there is, again, the defendants are not all going to go through the pretrial motions the same way. Some may have issues that relate specifically to them, others may not. And therefore, there will be separate hearings, separate motions, and that's inevitable in practically any case involving co-defendants. The concern about multiple hearings being done needlessly, which would be inefficient for me to hold a hearing on the same issue twice, just because there's two case numbers. I'll point out that has not happened in this case. That's not going to happen in this case if it can be avoided. But the situation we find ourselves in this case, quite frankly, is a situation that's probably the biggest issue that could be raised, which puts these two defendants in a different position. One is not competent and her case has stayed. The other is competent and wants to move forward. And so at this point, the case is still joined under 8B. I agree there was a single indictment. It charged both defendants. Each was assigned a separate case and a separate case number. Each defendant can elect how they wish to defend the charges against them, and they don't walk in lockstep on every issue that comes up in the case. They pursue their different remedies they think are available as they see as the case goes along. And inevitably, as I mentioned, there's probably going to be different hearings involving motions that may be only applicable to one of the defendants. So because the case is joined for trial right now, I don't see any reason or need to modify the order. I think the order is in compliance with Rule 8. I don't think there's any indication that the court's made any kind of severance in this case. The assignment of two case numbers does not sever the right of the state to seek a single trial in this case. And I will just note, for purposes of setting trial, it's the intention of the court, I am going to set one trial for both defendants, and we'll hope that we can get both defendants to trial. But where there's now a delay and no one knows how long that delay is going to be, at some point we may have to reconsider. All of the cases are pretty clear that while we look at economies and efficiency of having a single trial instead of two, that at some point may be outweighed by the substantive due process rights of each individual defendant, and severance may need to take place. Hasn't happened in this case. As Mr. Pryor pointed out, there's a pending motion to sever, which will be considered, but the court's made no ruling on that. And so for those reasons, we'll continue as we have been operating in the case with these case numbers and with the court's August order remaining in effect. So for those reasons, as stated here on the record, I'm denying the state's motion, and that'll be the ruling today. So
Your Honor, if
on that, go ahead, Ms. Blake.
Oh, sorry. Yes, Your Honor, the state does have a question. Will the court be issuing a written order with the findings contained in that written order?
I'll just issue an order indicating for the reasons stated on the record here, I'm denying the motion. All right, any questions on the ruling, Mr. Pryor?
Nothing further, Your Honor. Thank you.
Okay, counsel, thanks for your appearances this afternoon, and we'll be in recess.
Thank you, Your Honor.
You're welcome.